This is Ashley Bryant, petitioner, Travis Bryant, respondent. Again, thank you to all the parties for your patience in this matter. I did just this morning send you all an email. I don't know if you've had a chance to receive it or review it. It was about 45 minutes ago. So I thought what we could do is see if anyone has questions based on that. Oh, sorry, Mr. Zandy, go ahead.
No, I apologize, Judge. I was getting clarification from my legal assistant on the worksheets on this case. No,
Okay.
I think that's good. Thank you for getting that to us. My only question is attorney's fees. That was a request made by my client. It was largely uncontested. There was no response filed from Mr. Bryan. I don't know if he stipulated to that. Basically, I just need a number to plug into the money judgment in the attorney's fee section of the temporary order.
Thank you. I think your client's request was $2,000 towards attorney fees at this time.
Correct.
Okay. Ms. Gilmore, go ahead.
And that was contested. I think the issue was page length, but in a response, we were asking the court to deny the request for fees. I haven't received any materials. There's a pot of money being held where the fees would come from. At this point, my client's being forced to move out of the home and pay spousal support as well as child support. So I don't want to put him in a position where he can't comply with the orders and he's only accruing more and more debt. I don't think there's really a basis for attorney's fees in this case. There's not bad faith on either party, and honestly, there's not a huge disparity of incomes in the parties, especially with spousal support. So we asked the court to deny a request for fees. I do have some more clarifying questions, but we can address fees first.
Okay. I'm just going back though. Give me just a minute. I do want to clarify the worksheets that I'm adopting from the respondent. We'll just need to make that correction. I think it had petitioner and respondent in the wrong columns. So we'll just need to make sure that correction is made.
I can even present Mr. Zandy with worksheets since they were mine, with the spousal support included if that's easier, or you can plug in the net based on my analysis.
Right. Yeah. I just want to make sure that on page one, the income for Ashley is actually Travis's income and vice versa.
Yeah, that's different. Yeah.
Okay, perfect. So I just wanted to refresh my memory on the disparity in income here. I mean, per the worksheets I'm adopting, at least on a temporary basis, is essentially double. The spousal maintenance I'm ordering, just so the record is clear, and I think I did put this in my email, is primarily based on petitioner offering to pay the mortgage. So we're calling it spousal support, but it's a little bit of an offset because she's taking on additional financial obligations. So I do think $2,000 in attorney fees, given the gross disparity in income here, is appropriate at this time. This is not a ruling that future attorney fees would be awarded to petitioner by any means, but I do think up through this point to get us through temporary orders, it does make it's very reasonable, and I think it makes sense given the disparity in income and then the amount of debt that petitioner is voluntarily agreeing to take on through the temporary process.
And I have no problems with making that payable, and I've already drafted the proposed temporary order. I think I've included on there that it's payable by April 1st. So that gives him more than 3 months to make that payment, which helps with the transition. So I'm assuming that's appropriate.
That would be, I think that's more than appropriate. Ms. Gilmore, April 1st, basically 6 months. Obviously noting your objection to the payment in general.
Yeah. I understand 4 months is appropriate. I'll defer to the court, whatever the court would like to do.
I guess 5 months. I said 6 months, but okay. And then Ms. Gilmore, you had some clarifying questions, so go ahead.
So the court is adopting their proposed parenting plan. My main concern is particularly relating to the residential schedule. This schedule doesn't contemplate the fact that my client has a rotating 4-on 4-off schedule. So my concern is that under this proposal, he's going to have roughly 4 overnights a month. And if we don't consider or contemplate that rotating schedule, then he could even be losing out even further. So I would ask that we focus the schedule on the days that my client's off, and I'd ask that he have 3 overnights for the 4 that he is off. This schedule is consistent, and the parties have worked off of this schedule for the 19 years that he's worked there. So I think that would be appropriate. Is again 3 overnights for the 4 that he works or does not work.
That he does not work. Is that, Mr. Zandy, something that's agreeable to your client?
No, and again, this is the argument we made last month. Is this is an individual, and you had the information via pictures and declaration, everything else about the untreated drinking issues, and that's just been steady denial since. My client is again not trying to impede that relationship with Riker. She values that, she wants that, but she also wants it to be healthy and safe for him. This was a case where Ms. Bryant expressed her concern about a lot of the child now at the age of 12 being almost apathetic to dad and just expecting him to consume large quantities of alcohol. Certainly not healthy. I've got questions about 2 overnights with dad and if he's going to be able to keep his sobriety for that period of time. 3 overnights, again, I think is potentially a recipe for disaster if dad's making the same choices that he's traditionally made throughout the course of this relationship. So I think we can keep it the same. By my math and my calculations, he's going to have at least 2 weekends per month off from work. Certainly, Ms. Gilmore and I can tweak that language to if he's give him the child on his weekends that he has off. We can certainly be flexible with that, and I'm willing to. And I can include language in the parenting plan to that degree. But as far as giving him not just more time, but a significant amount of more time as being suggested, certainly does not align with your honor's order and certainly does not align with the concerns in this case, not just drinking, but domestic violence and the criminal charges and everything else. So that's kind of where we're at with that. I think leaving it the way it is certainly appropriate.
So here's my thought on this, and I'll just, be perfectly candid that one of the reasons I'm adopting a majority of the petitioner's parenting plan is, I understand respondents' arguments, but particularly his declaration seems to be kind of devoid of any accountability for substance abuse issues. Certainly someone with a DUI history that then says, yes, I've had DUIs, but now I only drink socially, essentially. It concerns the court. I think that is coupled, as Mr. Zandy pointed out, with the arrest for physicality towards individuals that will be close to the child. So, those really are the reasons that the court is primarily adopting the petitioner's temporary parenting plan until we have further input from the GAL, of course, and from evaluations. So I think what I'd like to do, let's keep weekends as is. If you and Mr. Zandy work on language that gives some flexibility and good faith efforts towards making those weekends where he is primarily off, I think that is important. The weekday right now is set Wednesday, 4:30 to 7:30. I could see, if the parties have a better way to craft this language, I think that would be helpful. But obviously he's not going to be off every Wednesday. I would be hopeful. I have less concerns about the daytime midweek visit. So perhaps if there was some language in there about flexibility on that day, 4:30 to 7:30 visit that coordinates with his 4-on, 4-off schedule. So maybe sometimes it's Tuesday, maybe sometimes it's Wednesday. I think that would be more appropriate than changing the overnights.
Yeah, I'm happy to do that. I'll just put 1 week. Father shall have at minimum 1 week to coincide with his day off from work from 4:30 to 7:30 as otherwise agreed by the parties.
Perfect.
And I think that would get us there.
Okay. Perfect.
I've got one last question.
Yes, of course. Go ahead.
We were asking that neither party expose the child to third-party romantic interests. I think this is going to be a huge change for this child, given the fact that these parties have been separated and continue to live together. So I would ask that the court put that restraint at least for 6 months or until the GAL can come out with an report.
Mr.
And unfortunately, this child is well aware of his dad's relationship with who was conveyed to be a employee during the hearing. That's not the case. This individual actually supplied a declaration talking about an affidavit form, talking about the relationship between the child and Mr. Bryant. So I although I would normally agree wholeheartedly with Ms. Gilmore, I don't think we can unring that bell. No, so child's already knows that dad's dating, knows who this person is. If the GAL wants to weigh in on that, we can certainly include that. Both of these parties are now in relationships. This marriage has been defunct for a while, as the court's aware. I would defer to Ms. Height and her input on that. But again, at this point, I'm not sure that this argument is based necessarily on the history and fairly recent at that.
Right. record, my client does not, I talked to him after the hearing because there was a lot of conversation that he's dating this individual. He is not dating this individual, and there is no evidence to the contrary. My concern is, and what's included in my client's declaration is this child specifically does not want to be involved in mother's relationship. So my client will tell you that he will not expose the child to any relationship. And I think that, again, this is a substantial change. So we have concerns that mother is going to move in her boyfriend, because she did have a plan on living with him, and then completely change this child's life.
And I understand. Yeah, go ahead.
I would just say this was not argued at the time of the hearing. So I don't really have any input from my client, but again, I'll defer to the GAL and we'll try to accommodate as best we can. But my understanding is child has met both new boyfriend and new girlfriend and is well aware of mom and dad's new relationships, and GAL might have more recent information than that.
And Ms. Hyde, I don't want to put you on the spot because this certainly wasn't anything anticipated that we would need input on. I think I know what my ruling is going to be, but go ahead if you have any information you want to give the court. I'm happy to hear it.
Just thank you, Your Honor. Just briefly, I would say that I have received intake packets back from both parties, and I have not yet met with them. So I have only that information, and the issues that have been discussed here in court are the very ones that have come up in my reading of their intake materials. So that's the sum total of what I can offer the court this morning.
Again, based on my reading of the declarations and listening again to argument from the parties previously, it does appear like we're trying to unring a bell that's already been rung. I think probably both parties have had people, whether they're friends or significant others, around that the kid is aware of. I don't, absent further input that those relationships are harmful, or that there's a concern that the GAL has about a significant other, I'm going to decline to put that in temporary orders. But I would note, and I'll put this in the clerk's minutes, that we will kind of make that a priority review point when we do have a GAL review at our next hearing date. And I'm not sure if we have set that date yet. We can certainly do that today. But if we need to do an interim bench order on that because of GAL concerns or because GAL isn't concerned, we can clarify that at our first review.
I think that review is March 20th, Your Honor, which...
Okay, did we set it out that far? Okay.
Well, we've got the final GAL report review for March 20th, 2024 at 9 a.m. I don't see any interim reviews contained in that order.
Okay.
I would like to set some sort of interim review, at least to check in and get see where the GAL is, maybe in late January, February.
Yeah, let's do that if the parties don't mind. We'll just set a review date. And again, I'll just kind of note one of the things we may bring up first is whether there's been any concern about significant others with kiddo. So what dates would you propose?
Your Honor, if I could just quickly weigh in.
Absolutely.
After the end of January, first part of February would be my help. That's what I would prefer.
Okay. What about February 7 at 9 a.m.?
That's fine.
Okay. Is it just, oh, hold on. There are two judges who can't hear it, and I'm trying to remember who will be, do you know who's doing that docket? You probably know more.
They're changing the rotation effective January 1st. So I believe it's Judge Hahn in the morning and it's Judge Basher in the afternoon. So I don't think either of them have been disqualified. So we should be fine on both fronts.
Perfect. Okay.
So that should be the 6th?
February 7th. Am I wrong?
Are we going back to the attorney docket since there isn't a affidavit on those two judges?
Let's say the 7th, it's Judge Evans in the morning.
Oh, we can't do February 7th because it's Judge Evans that morning.
So I think that we can just go back to attorney docket since we the judges have changed. So it would just be dependent on if we're even in odds if we'd be morning or afternoon on Tuesday.
Okay. Tuesday, February 6th. Can you tell me who's on those? So it would be 1 o'clock. And that is Judge Basher. So why don't I set you to February 6th at 1 o'clock? Okay.
Very well. Thank you.
And then let me just ask lastly, Did you want to submit those orders ex parte this week, or do you want, and I think I could do an 8:45 Friday presentation if needed.
I don't think we're going to need a presentation date. I think we've got pretty good direction on this. I'll ship those over to Ms. Gilmore by this afternoon. And then we can put our heads together if we need to and tweak some language. But I think we got the gist of what needs to happen. And if we need to note it on in front of your honor, we can always do that.
Okay. Yeah. And just shoot me an email. I mean, we could, if you shoot me an email late tomorrow, we can probably still get you on for Friday if we need to. So.
Excellent.
All right. Thank you all.
You.
I did note when I reviewed this case before today that you met with the courthouse facilitator, and they determined that these orders are ready for my signature. I note that we had a default order already entered against Mr. Newsom for his failure to respond or participate. And I have reviewed your orders. Unless you have any questions, I do believe they are ready to sign. Are there any questions you have for me?
I don't think so. I just if he wants to see the kids or do anything, he has to do that, right? I don't have to do anything.
So because
we still have a protection order. So that's what I'm confused about. Does the parenting plan trump the protection order, or does the protection order trump the parenting plan?
So in the parenting plan, I'll answer that in just a second, but in this parenting plan, you have no contact between Marcus and the child until he's completed a full disclosure drug and mental health evaluation with input from you, and has to comply with all recommendations. So that would need to be done before visitation would apply. Okay. But also, and are you saying that you have a separate standalone civil protection order?
Yeah, I think you were the one that granted it in May. Oh. But yeah, I got a protection order before I filed for divorce.
Okay. And I'm guessing we put that into place for about a year?
Yes.
Okay. Yeah, that does trump this, unless, let me go look at the language. Hold tight. I can pull that up. Sometimes I put language in the orders that state that the family law case can automatically amend the protection order. So let me see what I did in your case. Hold tight. Okay, that is in place for a year. Just looking through the language. So this actually was David Nelson, Commissioner Nelson.
Might have been the one that did the temporary one then. I remember being in court with you.
Yeah, I may have done one of your temporary orders. He did your year-long order, and he did put in language stating there is an exception to no contact, and he wrote the exception is, quote, according to a subsequent family law order. So that's pretty typical. So right now, what would apply to you is if I sign this today, your parenting plan would allow contact with the minor after there's been drug mental health evaluation and complies with all recommendations. And then once that happens, your visitation schedule, let's see if you put anything in here. I don't think there's any visitation actually outlined.
No, there's not. The person the lawyer that I met with to fill it all out said I didn't have to do that because of the evaluations and stuff.
Yeah, it just says to be determined after he completes recommendations. So what I would say is my thought is perhaps this is going to be up to you, but instead of marking what you've marked, stating that the following limitations or conditions apply, I think we should also check mark no contact with the children. And then if and when he complies with those drug and mental health evaluations, he or you could come back to court and request an adequate cause finding to determine visitation.
Okay.
Do you think that makes more sense?
Sure.
Because otherwise, I think you're in a weird position if he does comply and give you evaluations that maybe say he doesn't need any treatment. Then,
say that, I promise you. But
just for sake of argument, if that happened, right now your order doesn't indicate what visitation would look like. So you'd kind of be between a rock and a hard place, and he could technically have unfettered visitation. So one of the boxes instead that we could check on your parenting plan order is just no contact with the children.
Okay.
I'm going to add that and just initial. And then I'll put, yeah, I'll just initial that. That way, one of the two of you could come back to court if he complies and you need visitation set, but it sounds like that might be a remote possibility. Any other questions for me?
No, I don't think so.
Okay. All right, let me get these signed. Thank you for meeting with the courthouse facilitator and getting these documents.
Oh, wait, one random.
Yeah.
I do have a question. I don't think it's ever going to happen. But he took my dad's ashes, the only jar of my dad's ashes that I had, and that's like all I have of my dad.
Mm-hmm.
And I don't know how to go about trying to see if he still has that, or if I can. I doubt he even does have it, but if he has it somewhere, I would kind of like that.
Let's see if we put that. Did you add that in your?
I did in somewhere.
Sorry, say that again.
I did write it in there somewhere. I can't remember where.
Okay, let's see where it is here. But you did state respondent needs to return the jar of petitioner's father's ashes. That's in your findings and conclusions about a marriage. So it's in the order. That's about as far as I can go with giving you advice on how to actually get those back. But it is in a signed order now of our court.
Okay.
Okay. Let me make sure I got your child support worksheet signed. I'll get the child support order signed.
And how does that work too? Child support, do I have to do anything else for that, or will that just, the state will do it, or what?
So it looked like did you already have an administrative order in place?
I honestly don't know.
I think that's what the courthouse facilitator noted DCS would enforce the order because there is public assistance occurring. I think medical.
Yeah. And again, I doubt he's going to pay it, but it would be nice to get help.
Yeah, understood. Okay. I think I have got all your orders signed. And again, I appreciate your diligence in meeting with the courthouse facilitator and getting all of these in proper order for me. And if you don't have any other questions, then you are done with us unless and until you need a new determination on visitation down the road.
Okay. And then do I just come down to the courthouse later today, or should I wait a couple days to get the final order?
What's your thought? I'm so used to protection orders where they're ready in 20 minutes, but I know we don't, not in these cases.
Can hold them until the end of the day if she wants to come purchase copies this afternoon, because we won't be done until this afternoon.
Right.
If it's after today, then she'll need to wait a few days until they're in scanning for them to be printed off.
Okay.
To purchase copies.
Okay. So if you think you're going to come today, the clerk will hold on to them. You do have to purchase the copies. So if you want to come today, they'll hold on to them. Otherwise, you'd probably need to come back next week because it's going to take a few days for them to scan them into our digital system, and then they would be ready for you.
Okay, I get paid next week, so I'll just come next week, and then I don't have to worry about using my $20 to buy those.
Perfect. Okay. Well, thank you, and best of luck to you.
Thanks.
So you're divorced.
Okay.
Awesome.
Okay, I'm going to mute. Ms. Linden, can you hear the court?
I saw her in the waiting room.
She's here in the Zoom room.
Sorry, I was trying to.
There you are. Okay. Well, I don't have any updates, and I have nothing new in your file since we were all last here. I have not heard anything from Pacific County. So maybe one of you can give me an update if anything has proceeded in Pacific County.
If I may, Your Honor.
Go ahead.
So the last time we were here, you had told me to file whatever papers in Pacific County. I have. I did have a court date, the 4th of this month.
Mm-hmm.
I had a problem trying to serve Miss Linden. I made the legal attempts, but the judge told me to redo the process. Mm-hmm. I'm in that position right now to tie everything up to redo the serving.
Okay. So, Ms. Linden, any updates for the court? I mean, I still believe that this is properly in Pacific County, not here, but giving the parties some leeway to allow that process to play out. But I'm just not sure I want to take up more judicial time here in this court. But what can you tell me, ma'am?
The most I can really say is what I was told by the previous judge when I started all this is because his was thrown out, I got the okay to file And it was whichever one got their paperwork filed first got jurisdiction, is what I was told by the judge before I started filing.
Well, and you all filed first in Pacific County, though. So that's my point.
That's when that one got thrown out that I asked and got the okay that I could file, because he didn't have all his paperwork.
What time period are you talking about? Because we've gone through this numerous times, and the Pacific County case was opened before this one.
Mm-hmm. Yes, we had one or two with here. I got the paperwork. Mm-hmm. June 15th is the one where it got thrown out because he didn't have all the paperwork.
Well, I think you're using the word thrown out a little incorrectly. It's not thrown out. They maybe just didn't proceed on it because he hadn't served or done paperwork correctly, but it's showing as an active pending case. And the summons and petition was filed in Pacific County a month before you filed here. So it hasn't been dismissed. Has it been dismissed?
No, Your Honor, it has not.
Exactly. So that's my point, ma'am, is I think when you're saying thrown out, it hasn't been thrown out. They maybe just didn't proceed on taking action at a hearing, but it is an active pending case in Pacific County.
And if I may, Your Honor, the last time we were in Pacific County, Don Rickner, the judge who had overseen the case that day, had told Miss Linden she can respond via certified mail to Pacific County. That was what Miss Linden was told by the judges in Pacific County.
Yeah. So I'm going to just check. I know I did this last time. I'm going to check and see if Pacific County is still is retaining this case. And if so, rather than taking up additional judicial time, I'm going to dismiss this case without prejudice. That means that you are free to refile it here if for some reason Pacific County does not resolve. But I just don't want to take up more time on our docket when you all have the exact same case pending in a different county that went first. Means, yeah, motion hearing back in October of 2022. Parenting plan, motion hearing, the December 4th motion hearing before Judge Haywood.
That was the last judge I saw.
Okay, note for motion docket, motion to show cause, motion hearing. Yeah, so you guys have the exact same action pending in a different county. So what I'm going to do today, rather than have you keep coming back to this court, is I am going to issue a dismissal again without prejudice. And ma'am, what without prejudice means is it is going to terminate your case in this county for now, but without prejudice means you can refile. If, let's say, Pacific County were to terminate jurisdiction. Okay.
Yes, ma'am.
Okay. Any questions for me?
No, Your Honor.
Okay.
No.
All right. Thank you both.
You have a great day.
You too. So my docket notes indicate we had originally back in October had a motion hearing on what I believe were going to be temporary orders at that time, if that's correct. We did enter child support orders, but then we set over review hearings on some of the underlying requests, and I think specifically visitation. So maybe first I'll turn it over to our GAL to see where we're at and what we might be anticipating today.
Good morning, Your Honor. Thanks for your patience with me bouncing around a bit today. So at this point in time, I have received intake packets from both parties. However, I didn't receive Mr. Bissig's packet until late last week. I have attempted to set up a home visit and interview with him. I haven't heard back from him on that communication. I have met with Ms. Gibson at this point. I've gone through the case file superficially, and I've read through both of the intake packets. I have let Ms. Gibson know that what I'd be doing today is requesting that the court order both parties to get a hair follicle test. We have pretty serious substance abuse allegations from both parties. I have reasons to believe that Mr. Bissig is still consuming. And I know he's attending. He's been upfront about saying he's attending AA, NA, and participating in treatment. I would love to see his attendance sheet that's being signed for him, so I can see who is signing off on his attendance in that program. And I would love to have both parties receive a hair follicle test. That will give me some very much needed information.
So let me turn to petitioner first, Mr. Bissig. I am inclined to grant an order, specifically a hair follicle test for the GAL to be able to move forward with recommendations to the court. Do you have any objection to providing that?
No, but I did send that packet more than a week ago.
You may have. You may have sent it 2 weeks ago. She got it last week.
I sent it by email, so I don't see how that's possible.
Okay. Okay. Well, anyway,
I'm happy to pull up the date if we need to, but
good. No,
it's all right. I was just a little confused. That's fine.
Okay.
And I haven't received any word from the GL.
Ms. Gibson, can you hear the court?
Yes, I can, Your Honor.
Okay. Do you have any objection to undergoing a hair follicle test, hopefully before our next review hearing?
No, Your Honor, I have no objections to that. I just need to find a place to do that.
Okay.
And come up with the money, which I was going to ask my parents to help me with.
Okay. It looks like our next review hearing is January 17. I'm not sure what the timeline. I think people can get these done fairly quickly. Do you think there'll be any issue getting that done January 17? Ms. Call, do you think we need to set that out, or?
In terms of that being the final GAL review, I think it will need to be set out. I don't anticipate that we will have enough information by then to complete a report, especially with the holidays between now and then. Okay. There's been quite a delay in trying to get these appointments set up. But I believe if they're both able to get in at Awakenings, I believe they can get that hair follicle test done fairly quickly and get the results back. This time of year, I imagine results are going to take a week or two to get returned. I mean, I think we're going to have to push the final GAL review, but I think we could get the hair follicle within that time frame.
Okay.
Your Honor.
Yeah, go ahead.
I did call Awakenings, and they do not do 5-panel hair follicle testing, because I did call the same day that I had a meeting with Miss Call.
Okay.
And they do not do those. That's why I'm saying I have to find somewhere to do it. And I'm potentially going to see, I looked up some places. Quest Diagnostics here in town might potentially do it. So I am going to call there. And if they do, I would be more than happy to message Mr. Bissig and let him know that they do or do not do it so that he can get his done as well.
Okay. I think that is helpful. Let's, was there anything regarding visitation that the parties needed to re-review today? Otherwise, I think I will set out, I think I'll probably cancel our January 17th hearing and move that into maybe mid to late February.
There was one thing that me and the guardian ad litem had talked about that I would like to bring up. Mr. Bissig does not have the correct car seat for the 2-year-old Aries. He needs to be in a 5-point harness car seat, not a booster seat that is used with a seatbelt.
That's not true, Your Honor. She hasn't seen the inside of my parents' car.
I do. Well, hold on, you two. No. Address all of your comments to me, not each other. So Mr. Bissig, when you say that is not true, what do you mean?
That she hasn't seen what car seats I put him in.
Okay. Do you have him in a 5-point harness?
I do.
Can you provide a picture of that 5-point harness car seat in your car to the GAL?
Yes, if necessary.
It is necessary. So
yeah,
I am going to put in an order, and let me just triple check. The youngest child is how old?
He's 2.5.
Yeah, so he does need a 5-point harness. So I am going to put in the bench order that since you say you already have it, I'm going to say within 24 hours, I want you to send a picture of a 5-point harness car seat in your car. So the picture needs to show that it is your vehicle or whatever vehicle. If it's your parents' vehicle, fine. It just needs to show that it is the vehicle that you pick up or drive the child in. with a 5-point harness car seat. And until the GAL has that, I do think it is inappropriate for you to be driving the child around, because a booster seat is not appropriate for a 2.5-year-old. It is not safe.
Well, the person who is watching and supervising me is here, and she can verify that's not true.
I don't need to take anyone's word for it. I'm just asking you to send a picture of it in the vehicle to the GAL.
Okay.
Are you not able to do that?
No, I said that's fine.
Okay.
I did.
Sorry. Go ahead.
I did have 2 more things I wanted to discuss. One was I wanted to speak with you about potentially extending a visitation time. Extending the amount of time for visitation on the 23rd, so that Mr. Bissick could get more time with them on the 23rd to do Christmas with them, potentially going to 6 hours that day instead of the 4.
And since that is more visitation and not less, if the two of you agree on that, I am fine with it. I don't need to put that in an order. If it's a holiday thing and you're not asking me to restrict visitation, you just want to give them a little more time. Mr. Bissick, I assume you're in agreement with that?
Yeah, that'd be nice.
Perfect. There we go. I think that's all that needs to happen on that issue. Yeah.
I wasn't sure. I wanted to just double check. And then the last thing was, I had messaged Mr. Bissick on November 30th to give him 15 days notice of a trip that me and the kids will be taking to visit my mom and my stepdad for their Christmas with their grandparents. I let him know that because we have been doing Saturdays, we will need to work something else out. It is now the 13th. We leave on Friday, which is the 15th. We will not be returning till the 17th.
Okay.
There's been no communication. I verbally reminded him last Saturday. He has not communicated with me about what he wants to do for visitation. So I'm not sure what I should be doing, because I don't want to get in trouble for not having visitation, but I have given him ample time to communicate with me and to work something out with me for visitation this week.
Understood. So what day? So while you're gone, will he just be missing one visitation day?
Yeah. So we've only been doing it once a week, Saturdays from 3 p.m. to 7 p.m. because there's no set day that we have to do it.
Right.
That's just what has been working for both of us. But seeing as we will be gone this Saturday, I wanted to give him ample time to work out something else with me.
Is there a makeup day, Mr. Bissick, that will work for you because they will be gone this upcoming Saturday?
Well, it's supposed to be 1 to 2 days a week, and she's only given me one.
Yeah, it does say 1 to 2 times per week, but that's not my question. My question is, since they will be gone this Saturday, and I'm not going to preclude her from being gone over a Saturday for a holiday trip, my question is there a makeup day this week or next week that would take the place of this Saturday for you, that works for you and the supervisor?
I'm pretty sure we can figure something out.
Well, why don't we do it here? Because it sounds like, I feel like this is going to be a little bit stressful for her, and you seem a little ambivalent about whether you're going to work with her on this. So I would like to set that date here. You said you have the supervisor with you. What will work? What will work for the two of you?
How about Friday before they leave?
Well, I think they're leaving.
So Friday would work if it was the 3 to 7 like we originally planned. We have to be at the train station by 7:30 on Friday. So that would work for me.
This Friday, meaning in 2 days?
Yes. If the 3 to 7 would work, or any time from after 3 to 7 o'clock, that would work for me.
Mr. Bissick, does that work for you? I feel like that's cutting it a little close for getting your train, but if you think it'll work, I'm happy.
Well, it's right there by the police station.
Yeah, the police station and the train station are right next to each other, so that works.
Oh, that's true. That is right up here. Okay. Well, Mr. Bissick and Ms. Gibson, if that works for you, I think that's great. It gives me a little travel stress, but if it works for the two of you, I'm all in favor of it.
That works for me if that works for him.
Okay. I know I'm one of those people that shows up like 4 hours early for my flight. So
our train doesn't leave till 8. That's why I'm saying we have to be there at 7:30.
Oh, okay. I thought it was leaving at 7:30.
No, 8 o'clock.
Okay. So let's go ahead, and then also I'm not, again, since it's just a one-off, I'm not going to put that in a specific order, but it will be in the clerk's minutes if an issue comes up that we need to address. But what I am going to say this week, instead of Saturday, Mr. Bissick, go ahead and plan on Friday from 3 to 7. Okay.
It's not like I have a choice in the matter.
Well, you do. I asked you what worked for you. So, and the choice is, what I'm telling you is, I'm not going to preclude a travel trip over the holidays. So we're trying to find a date that works for you. That's kind of part of parenting through a separation, is it's maybe not always going to be either party's first choice, but I'm asking what is workable. So if Friday doesn't work,
what's workable is I should be able to get my 2 days a week.
All right, sir, I'm not going to get in an argument with you. What I'm asking is Friday a sufficient day for you? Does it work for you? Or do you want to look at a different day, perhaps next week?
That works.
Okay. Okay, anything else we need to do before I look at new dates for our case?
That's all I had, Your Honor.
Okay, so in the bench order today, I'm going to be requiring hair follicle testing by both parties. Let's say, try to get those done. I'll say 3 weeks, just because I know holidays are coming up and I know that you might need to save a little money for it. But unless Ms. Call, you want that to be a tighter turnaround.
No, I think that's fair. I think both of these parties are going to need a minute to put that in order. And I offer my apologies to Ms. Gibson. I thought Awakenings would be able to do that for her. I must have had some wires crossed there on location.
Okay.
That's okay.
And then I will require in the next 24 hours that Mr. Bissick send confirmation of the 5-point harness in the car that the minor child will be in, the youngest child. So let's cancel January 17th. And certainly this doesn't preclude any party from noting an issue on to our Wednesday docket if something comes up. But instead of doing the formal review date on January 17th, let's go out to, let's try for February, well, how about February 21, Wednesday at 9 a.m.?
That works for me, Your Honor.
That works for me.
And Mr. Bissick, does Wednesday, February 21 work for you?
Perfect.
Okay. All right, we've got you on there. And I will get that bench order written. Anything else either you need from me today?
Nope.
No, Your Honor, I'm got everything I needed today. Thank you.
Okay, thank you. Ms. Call, anything from you?
That's all I needed. Thank you, Your Honor.
Okay, good morning, folks.
Good morning, Your Honor. Stephen Swenson for Michael Taft.
Okay.
Good morning.
Ms. Taft, can you hear the court?
Yeah, I can hear you.
Okay, and Mr. Taft, can you hear the court?
Yes.
Okay, so here's what I show, and Ms. Taft is aware of this. The respondent, Mr. Taft, through counsel, has filed a motion for reconsideration to my November 15th, 2023 order. I do need to make a ruling on that. It wasn't specifically noted on for today. What today was supposed to be is a review on the contempt and in a potential payment plan. So my thought on proceeding number one was, Ms. Taft, I wanted to find out from you if you plan to submit a formal response to the motion for reconsideration.
No, because I feel like that's ridiculous. And I mean, not only did you decide that he had to repay that, another judge already decided that he had to repay me. He already got out of the spousal support. So I feel like this is ridiculous and uncalled for. And I feel like they're trying to pull anything they can just to get out of it.
Well, and I'll just state for the record, I haven't made a ruling yet on the motion for reconsideration because I need to.
Sorry.
Yeah. So here's my question first is, are you planning to submit any materials on the motion for reconsideration?
Like what?
Well, I can't give you legal advice, so I'm at it. It's essentially a yes or no question.
Oh,
honestly,
I feel like I need to be appointed attorney. I've been looking for an attorney. I feel like at this point, I feel like I need an attorney because his attorney, I feel like, is antagonizing me. And when it came to you telling Michael that he was supposed to communicate with me to set up a payment plan, and wants to email me about some BS, about some mail that had nothing to do with this.
Well, yeah. So, ma'am, I'd like to slow down there a little bit. I do have concerns with I don't have concerns with how Mr. Swenson has communicated with you. I do have concerns about the language that you're using towards Mr. Swenson in your communications.
Yeah, and I feel like he's taking it out of content, like, because this is a sensitive subject for me, and it is a sensitive case because it's still like a sore case.
Of course. So let's, Ms. Teft, I'm going to slow down here. Every time a family dissolves, it is absolutely a sensitive subject. I know that. I get it 100%. I want you to know that. What I need to know today are very objective things. So the first objective thing I need to know from you, yes or no, is, are you planning to submit any materials in response or objection to the motion for reconsideration?
No, because I feel like I've submitted everything that shows, as far as him taking the money and the money going in his account, and him lying, saying that he paid me back when he didn't. I think I've submitted all my proof to show that, and I think I've proved that.
Okay. So I'm just going to make a note then that you are not planning to submit any further materials on the motion for reconsideration. So I can't, and you have received the motion, correct?
Yes.
Okay. So I am going to find that this motion is ready for a decision. I will be the one issuing that decision. I don't do it on the record. It's a written decision that I send to the parties. And so today, because that motion for reconsideration has been filed, since we were on for review hearing on the contempt order that is now the subject of a motion for reconsideration, I'm not going to take action or hold a review hearing. I am going to issue a bench order that stays the contempt order pending my decision on the motion for reconsideration. And then I'm going to set you all a new review date in the hopes that you all have received my ruling on the motion for reconsideration by that time. Does that work for you, Mr. Swenson?
Yes, Your Honor.
And does that work for you, Ms. Teft?
Just to clarify, your decision, is that a yes, they're going to be reconsidered, or no, they're not?
I'm sorry, I couldn't hear your question.
Okay. Oh, I'm a little confused on your decision for the reconsideration. Was that a yes for it?
I have not issued a decision on their motion for reconsideration. I will be doing that. I just needed to know if I should wait for more documents from you before issuing that decision.
Oh, okay.
Okay, so it sounds like no. So with that, I will, on a future date, make my ruling on the motion for reconsideration. What I'm doing today is issuing what's called a stay of the contempt order from November 15th. And what it will say is a motion for reconsideration has been filed. A decision is pending. Therefore, the court's November 15, 2023 contempt order is stayed pending a further decision. What a stay means is the contempt now is not a final decision, and it doesn't hold any, it can't be enforced right now. And then once I make my ruling on the motion for reconsideration, either we will put back into place the contempt order or it will be vacated. Okay. One of those two options. So right now we're just in a holding pattern until we decide the motion for reconsideration. Does that make sense?
Yeah, but can I get appointed attorney? Because I feel like I need.
You've asked for this before. The answer is no. You are the petitioner in a family law matter. The reason Mr. Teft was appointed counsel by the court was because you did and have continued up through very recently to request jail time for him. When jail time is requested, folks have the right to court-appointed counsel. You are not being threatened with jail time. So I am declining once again to appoint counsel to you. There are other low and no cost legal services available to you that you can reach out to if you would like to discuss low or no cost representation on a family law matter.
That's what I've been doing. Okay.
So let's set a new review date. I'm hopeful to get, since this is ready for a decision now, I'm going to try and get a decision out to you within 30 days of the date the motion was filed, which I think was the 21st. Yeah, November 21. So I'm hopeful to get a decision out to you by December 21. So let's set a review for, are the parties available that week between Christmas and New Year's, or we could set this into January?
Yeah, I'm available.
I'm hoping to take that week off.
Understood.
January is available.
Okay. What if we set it for January 3rd at 9 a.m.?
That's the day of the contempt of court that I filed against Michael for this month, because I did file another contempt of court, which I just filed, and I should be, they should have a copy too as well, but the hearing date is
you're already on that docket, you said?
Yeah, January 3rd. I have just filed it literally recently.
Okay. Yeah, I don't see it in here yet. So that will work then. It sounds like you already have that date set aside. So we'll set the contempt review for January 3rd, 2024 at 9 a.m. Unless, did this get set on the attorney represented docket now? Maybe I'm mistaken.
Actually, yeah, I think it might have been on the 2nd, which is a Tuesday. However, I just feel like this has been going on for a whole year now. Like,
do you know, Mr. Swenson, have we switched you over to the attorney represented docket, but for, well, let's do this. Well, it won't be me anyway. I'm not doing this docket next year. So Mr. Swenson, do you have a preference whether we put you on attorney represented on Tuesdays or whether we stick with self-represented Wednesdays?
My office is closed Tuesday the 2nd, but okay. I don't have a preference whether it's a pro se docket or attorney represented.
Let's stick for now, since this is such a unique case, let's stick for January 3rd at 9 a.m. on the self-represented docket. Okay, Ms. Taft?
Yeah.
Okay. All right. Well, thank you both. Anything else we need to do today?
What was you said you're going to have the decision within like this month?
Yeah, that is my hope.
Okay. So we're not going to do the review on the 21st then of December, as you said?
Do we have a review on the 21st?
No, it's the issuing the decision.
Yeah, so that's not a formal review date. That's just a date so December 21st would be 1 month since the motion for reconsideration was filed. And that is our typical timeline for responding to a motion for reconsideration. But ma'am, that is not a court date.
Okay.
Okay.
Well, at this point, I feel like I'm over this because this has been going on for a year. And I can't. This is too much stress on me.
Okay. Well, I would just implore you to use a little bit better language when you're dealing with Mr. Swenson. Okay.
I did send him a message apologizing and telling him not to take this out of content because I told him that it was emotional.
I understand. Okay. We'll see you back January 3rd. Thank you all.
Your Honor, I believe Francisco is on, but I have not seen Elisa.
There is someone logged in with an iPhone that doesn't have a name on it. Can you unmute and tell the court your name? Oh, there's also an iPad. If you are on Zoom, oh, go ahead. I see the iPhone unmuted.
My name's Heather Lucor.
Okay. Oh, okay. We'll come to your case. You are the very last on our docket. I have 2 cases before we get to yours.
Okay.
Okay. Thank you. So I don't see Ms. Gutierrez here. I have this on for a review hearing. Mr. Lawrence, what are you able to tell the court?
Well, as the court is aware, we've been having hearing after hearing as the court had asked Mr. Gutierrez to obtain a drug and alcohol evaluation. And we had him go about a month ago, and the counselor did not want to take input from myself or Ms. Gutierrez. And the court reiterated that he needed to complete the evaluation. I did receive contact about 2 weeks ago from Kaiser, and they took my input, and I sent a copy of my guardian ad litem report to the counselor. And I have not received any word that the evaluation is completed and haven't received a copy of it if it has been.
Okay. I appreciate that input. Mr. Gutierrez, what do you know that might be in addition to that information? We can.
Okay. All right. Sorry about that.
Nope, you're fine. So what can you tell us? Any update on the evaluation process on your end?
I believe I thought that was done. I didn't know. Counselor talked to me after she spoke to Lawrence and Elisa, and she told me I had a phone call with her informing me that it was done. So I don't understand the communication between the counselor and Lawrence, or the communication between the counselor and Elisa. So I don't know.
Well, here's my thought, because we do need that input and it does impact your case. So I would implore you, a lot of times people tell me, oh, I expect the counselor will reach out to the GAL. And I always say, since this is your life and your case, I recommend you reach out to your counselor and make sure that they're getting what they need to the GAL. Okay. So my thought is we do a short set over, especially since we don't have Ms. Gutierrez here today. For unknown reasons, I will note that she has appeared at every other date. So I don't know what happened in this specific instance. So I'm not going to take action today. Let's do a short set over. And Mr. Gutierrez, if you can get a hold of your counselor and just make sure they're in touch with Mr. Lawrence, that will be really helpful for us moving forward.
Can I ask Mr. Well, I guess I can do it. I don't have to do it on here. I don't know what he wants from the counselor, but okay.
Yeah, why don't you reach out to Mr. Lawrence? He can certainly clarify that for you. He has no problem doing that.
Your Honor, all I need is a copy of the evaluation.
Is that helpful to you, Mr. Gutierrez?
Yeah.
Okay. How much time do the parties want to do that? And I think one or both of you, if you could reach out to Ms. Gutierrez with this date, that would be helpful too, so that we can move forward.
I can do that, Your Honor.
Okay. I mean, I could set this over just 1 week to December 20th if we think the evaluation's been done. Or we could go out 2 weeks to December 27th if folks are available. Again, like I said to the prior case, I know that week between Christmas and New Year's is a tricky one for folks.
I should be available.
Mr. Lawrence, what's your holiday availability?
I'm available, Your Honor. I don't know what Elisa's schedule is or how involved it may be to get the report, but why don't we try for next week?
Okay. Let's try for December 20th. So Mr. Gutierrez, if you could reach out today to the counselor and just let them know Mr. Lawrence is needing that report, we might be able to move forward on the 20th. Okay.
Okay.
So we'll just set this review over 1 week to December 20th at 9 a.m. When we were together last on November 15th, we were still dealing with questions about reunification counseling, and I don't have anything new since that time. I know Mr. Utter had routinely been requesting a change in visitation, and my last ruling was I really wanted to see reunification counseling occurring. I again don't have any update on that. So let me start with Mr. Lawrence and then I'll come over to the parties.
Your Honor, I reached out to both of them yesterday to see how it was going. Ms. Young did return an email last night, and she indicated that the reunification counseling has started. The counselor has been meeting individually with the parties, and that Stevie is scheduled to have his first joint interview with Parker tomorrow. And so Parker has been somewhat resistive, according to Ms. Young, but hopefully this will improve as this counseling proceeds.
Okay. Let me go. Yep, go ahead, ma'am. Ms. Young, go ahead.
Oh, I was just going to say their first meeting is tomorrow at 4.
Okay. And Mr. Lawrence, you haven't received any documentation from the counselor about recommendations for visitation through this process yet or anything, have you?
No, I have not, Your Honor. And at this preliminary stage, I would expect to not have anything yet.
Okay. Mr. Utter, any updates you want to give the court?
No, that's really exciting news. I'm really grateful for that. I've met with Patricia twice now, and the last time I'd met with her, she had said that she wanted to meet with Parker, but didn't know if he was going to be willing or wanting to meet with the both of us yet. So just hearing Mr. Lawrence and Kirby saying that there's a scheduled visit tomorrow is huge. That's amazing.
Okay.
Thank you.
And you've been able to meet with the counselor, correct?
Correct, twice. Tomorrow will be my third visit. So it was scheduled for my third visit regardless if Parker wanted to or not. So this, like I said, this is just, I'm out of my skin. This is great.
Okay, great. That's really good news. My thought that I'm not going to take any action today until we get a little further along in this process and I have some input from the counselor to Mr. Lawrence and then Mr. Lawrence to the court. But Mr. Utter, I don't want you to get discouraged. This is just step by step. This is not any decision about what your entire future looks like. You guys are finally on the right track, I think. So just keep doing what you're doing.
I understand that, Your Honor. Can I ask about holidays though? I know, you just said we can't do anything different now, but being as I was able to have him last Christmas,
that's
was
not
hoping.
correct.
Well, so the difference probably, and even if I were to assume last Christmas, there was some sort of different arrangement. What has happened since is this court back in October did specifically state that any visitation allowed in the temporary parenting plan was put on hold pending reunification counseling. So there has been a change, in reviewing your file from where you all were at perhaps last Christmas, if you did in fact have visitation. Ms. Young, are you asking the court to review holiday visitation, or what is your request at this time as you guys start this reunification process?
I think there needs to be input from the counselor at this time.
Yeah, and I would tend to agree with that. I think, Mr. Utter, what we need to do, and I, believe me, understand your request and your position. I do want to just set a new review date for you all in the hopes that the counselor gives some input about what that should look like. Mr. Lawrence, what would be your thought about how far out we go with this?
I would suggest 30 to 45 days, Your Honor, to give it a good chance.
Yeah. I think that does make sense. Are you all doing, is there telephone visitation right now?
No, I haven't been able to talk. That was one thing I asked our last court date, and you had said not until you heard back from the unification counselor.
Ms. Young, and my order is what it is. There is no visitation right now while they're in reunification counseling. Is there any realm in which a phone call, on Christmas Day makes sense to you, or is that something you're just adamantly opposed to?
No, I can have Parker call him Christmas Day.
Mr. Utter, would that work for you?
Yes, Your Honor. Anytime works for me that I get to talk to him. Yes.
And what I'll say is, I think a Christmas Day phone call makes sense. I would want Ms. Young, you to be present for that, just to make sure that nothing goes off the rails and it's not a setback for the parties as they go through this process.
Okay.
But if you are comfortable with it, then I think that is a fine solution for the holidays.
Okay.
Okay. Let's set your review just to give this time so that we can actually take action rather than, I know, Mr. Utter, it must be frustrating to come here and just, be told we need to wait. So
it's a roller coaster.
Yeah, I do understand. I think if we set this out, let's say to January 31st, that's 7 weeks. My hope is that we'll have some input by then. Will Wednesday, January 31st at 9 a.m. work for the parties?
Yes.
Yes.
And Mr. Lawrence, does that work for you?
Yes.
Okay. Does either party, are you requesting that I issue an order allowing the Christmas Day phone call, or do you think the two of you are fine with my oral ruling on that and can make that happen?
I think we can make that happen.
Okay.
Agreed.
Okay. Ms. Young, I appreciate your willingness on that. Anything else from the parties or Mr. Lawrence?
I don't think so.
No, ma'am.
I have nothing, Your Honor.
Okay. All right. Well, thank you all. We will see you back January 31 at 9 a.m.
Thank you.
I did review this file previously, and we've got a lot going on here, and we have a lot that is scheduled for future days. So I know you both are unrepresented, so I'm first just going to tell you what is properly before the court today and what is set for future dates. So today, what has been set on, I know that, and let me just see, I'm not sure if Mr. Denlocker is with us.
I don't know why it keeps going to mute.
Okay.
Sorry about that.
And then somehow the camera's on the ceiling. There, we can see it now. Okay.
Good morning.
Good morning. So what actually is set for today is a review of the restraining order request from petitioner. What is set for future dates is essentially everything else, but Ms. Lucor has filed her own request for temporary orders and a restraining order. That has been noted on for our January 3rd docket. Mr. Denlocker, I see that you have also filed proposed parenting plans, or a proposed parenting plan, but I don't see that you actually noted those on for any specific date. The only thing that's been noted on officially and served on Ms. Lucor is the restraining order request. So the immediate restraining order and hearing notice was served on her November 22nd. So that's all that I'm able to move forward on today.
What needs to happen for the proposed parenting plan to be in place?
Yeah, so much like you may have received from Ms. Lucor, there's actually a note for motion docket for the court to review the your proposal, your request for temporary orders.
Sure.
So that hasn't been docketed yet. The only thing you actually docketed was the show cause order for the restraining order.
And how do I go about that?
So if you come into our Superior Court Clerk's office, there is a form, and you'll see Ms. Lucor filed it. It's called a family law calendar notice. I don't know.
He could have received that on Monday. He was served with the papers.
Yeah, that's not what we're talking about right now.
Oh, okay.
We're talking about him filing his own if he wants to get his orders on the docket.
Oh, okay.
So it's called a family law calendar notice.
Okay.
Okay. So Ms. Lucor, what I won't be doing today is reviewing your temporary orders or his temporary orders or your request for the restraining order. The only thing in front of me today is his request for a restraining order. So I'm just going to start with that. Mr. Denlocker, are you requesting that this court keep a restraining order in place, restricting Ms. Lucor from contact with the minor child?
Yes, Your Honor. And I do have a question.
Well, just a second. I'll get there in a second. I received the original request for the restraining order. Ms. Lucor, I have received your response to it. But just today, I received a bench copy of a declaration of Ryan Denlocker in support of the restraining order. It includes text messages, or I don't know if these are social media messages or text messages.
Email.
Oh, email from an Ellen Jordan. And then it also includes elementary school attendance records. And then it also includes Mr. Denlocker's, it looks like UAs. Ms. Lucor, have you received this information?
No.
Mr. Denlocker, did you serve this information on her?
I did. I've gone through Heather's paperwork that she served me with at 10 o'clock night before last. In the paperwork, she checked the box that she could be served via email. I emailed her those papers last night. I don't know how else to reach her because she's not often home.
I guess let's start with this. Well, service, whether it's in person or by email, 24 hours before a hearing or less would not be sufficient for me to consider the evidence. But Ms. Lucor, are you in agreement to receive service in this case via email?
I would prefer it be in person just so that I could confirm that I had it. I can look it over on my email. I didn't get any alerts saying that I had an email from him, but he never emails me, so it very well could have went to a different folder or something. I'm not 100% sure. So I would prefer to have it in person though.
Okay, so here would be my proposal today, because I do think that there's additional information in this packet as it pertains to the restraining order that Ms. Lucor, has the right to respond to before I decide on a lengthier restraining order or not. So my proposal would be, so Mr. Denlocker, number one, going forward, it sounds like personal service needs to be made, not email. But for purposes of this restraining order motion, Ms. Lucor, we'll assume, if you do have it in your email, we'll assume that that has been served on you. And what if I give you a few days to respond to it, and we'll have you all back next Wednesday at 9 a.m. on his motion for his restraining order? That gives you time to look through his materials and respond.
Okay. So would she stay with him then that whole time?
Yeah, what I would do is just for the 1 week, I would just reissue the temporary order. So I'm not making any ruling on a permanent restraining order. It's just that ex parte temporary order that would be extended through next Wednesday at 9 a.m. to give you time to formulate your testimony in objection to it.
Okay. Is it being considered that as far as child support and everything, I'm listed as the custodial parent? I know that we don't have a parenting plan in this case already set, but we already have everything with child support already set up through the state. I received TANF, and I was listed as the custodial parent, and he completely cut off contact between me and my daughter when I was in Tennessee when my grandma was dying. And that was the only reason I was in Tennessee for those 5 days. And that was when he decided for the first time her entire life to keep her from me. And that was when he filed, was I think November 20th originally.
Yeah, and I did see that in your responsive documents. And what I'll say, just two things. Number one, your request for temporary orders and your own restraining order is on docket for January 3rd. Mm-hmm. So that's when those questions would be addressed. Okay. All I'm doing today is setting over his restraining order request to next Wednesday. Look through his materials and file any responses you want to it. It does include school attendance documents and some allegations of substance abuse on your end. Whatever you can provide to the court in response will be helpful when we're back here on Wednesday.
Okay.
Okay. Anything else from the parties right now?
So in my restraining order, I thought that I had added comments that there was things to be fulfilled by the court for court order.
Let's see. What do you mean by that? You need to be a little more specific.
I asked if she could provide a hair follicle test and amongst other things to have the restraining order in place for today.
Let me look. You did request those. Let me see what the judge signed. The judge did not. The judge who reviewed this ex parte did not include those items in the temporary ex parte order. That is very common. We typically wouldn't require those things unless we're approving an order after a full hearing.
I see.
So those are your requests, and we will deal with that next week when I decide whether to reissue this to issue a restraining order that is no longer temporary in nature. Okay. But that will be based on the evidence that's presented to me before next Wednesday or at the time of testimony next Wednesday. So typically how I handle these is you both will file your written documentation. Mr. Denlocker, you've already done that. I'm giving Ms. Lucor time to file additional documents in response to your documents. Then we'll come back Wednesday. I'll swear you both in. You'll have a chance to actually give testimony under penalty of perjury about your request, sir, and ma'am, your objection. And then I'll make a ruling about whether more likely than not, I believe a restraining order is necessary.
Thank you.
Okay.
May I ask a question?
Sure.
As far as the restraining order goes, am I allowed to contact her school as far as the attendance records?
Let's see, what did they... Let me just look at the temporary order. Hold tight. It's just, you can't go on right now until we just go to a full hearing. Temporarily, you cannot go onto the grounds of the school or enter the school. You can't be within 1,000 feet of the school, but that is it. So there is no prohibition on you contacting the school by phone.
Okay.
Mm-hmm. Okay.
You also, this is to Heather.
Well, hold on. No. Everything in the hearings needs to be directed to me.
Oh, I'm sorry. Your Honor, she will see in the paperwork that I sent her, all the school attendance and everything is all attached.
Yeah. So I did receive those documents. So the attendance records, ma'am, are in there. So you can look through those, but there's nothing that precludes you from calling to clarify.
Sure.
Okay. Well,
and also, if I do set up a drug test or hair follicle test prior to next Wednesday, all of that is put into consideration when it comes to the restraining order. It just won't be looked at until Wednesday.
Correct. Just make sure it's submitted to the court and served on Mr. Denlocker.
Okay.
Okay. Okay. Well, thank you both. We'll see you back Wednesday, just next Wednesday. What is that? December 20th? At 9 a.m.
Okay. And it's the same docket.
Same docket. The link will be family law self-represented 9 a.m.
Okay. Thank you.
All right. Thank you both.